Hello and welcome back to another video on my channel. Today I'm going to be discussing or sharing a little bit of advice or wisdom for those coming up on their torts final exams. Final season is officially upon us, so without further ado, I'm going to share one of the things that I did on my torts exam that I credit with helping me to get an A on that exam. Ultimately, it is a discussion of the far underutilized but often talked about Palsgraf factors, okay? So Palsgraf is a very important case for torts that I believe most anybody watching this would have read when they were in law school, but I think what people fail to appreciate is its utility on an exam, specifically when you're dealing with a case that seems like it might have an attenuated causation issue. So without further ado, let's go ahead and get into how to best use this. I'm going to start off by showing the actual factors in listed form. So majority, you're going to want to apply a but-for test for your causation. In a minority jurisdiction, you'll want to use the factual cause approach if negligence is either a but-for cause or a substantial factor cause. You just want one or the other. And in Texas, you're looking for negligence to be both but-for cause and substantial factor. So that's when, in this analysis, you want to make sure this is applicable, and then you move on to the Palsgraf factors. Now, the multi-factor test in the dissent is going to be conduct as a substantial factor in causing the plaintiff's harm, natural and continuous sequence of events, the directness, that being were there many intervening causes, and then we're going to look to remoteness in time and space. Now, Palsgraf, as we all remember, is the case in which someone is attempting to board a train and then the guardsmen for the railroad company push the person into the train, pull them into the train, they drop a box full of fireworks, it goes under the wheel, explodes, knocks over a weight or a balance, something on the train platform, and it falls on Miss Palsgraf, who is now the plaintiff. The case at large is placing limitations on liability in negligence cases. Cardozo talks about the fact that negligence in the air will not do, and it needs to be a reasonably foreseeable consequence of somebody's negligence. The minority view, and that being the dissent, is a duty to one is a duty to all, meaning that if the injury can be traced to the wrongful act, with no intervening factors, then this is sufficient to establish liability. So if it can be traced back, then it should be traced back, is sort of what it is standing for, and that is the broader but-for causation. Of course, this has to have limitations, and those are discussed by the dissent. So let's go ahead and let's look at the case and see how these factors were applied. So I'm going to go ahead and open it up, and this is where that idea, the zone of danger, kind of comes up. That zone of danger is what we get from the majority, and if it's outside of the zone of danger, it's outside of liability purposes. So nothing in the situation here gave notice that the falling package had in it the potency of peril to persons thus removed. Negligence is not actionable unless it involves the invasion of a legally protected interest, and proof of negligence in the air, so to speak, will not suffice. So that's something that on your torts exam you could throw in. Negligence in the air is not enough as established in the Palsgraf case, and then that could lead to your discussion of what is enough to establish it. So some professors might appreciate that little nod and a wink if they are really big nerds, especially about Palsgraf or Justice Cardozo in general, of which I have had quite a few nerdy professors who like those. Okay, so this next highlight is also where we get the zone of danger analysis, an idea from this talking about reasonable risk to another, and within the range of apprehension. Obviously, range of apprehension is not as catchy as zone of danger. And here, Justice Cardozo talks about speeding down a busy street versus speeding on a race course, and the difference being the danger. Okay, so moving on to this next comment that I have highlighted here. This is from the dissent in Palsgraf, and the dissent is where I believe the utility for our exam purposes really shines and gives you the opportunity to set yourself apart, because the dissent explores those factors I previously mentioned that serve as limiting principles that allow you to kind of play with liability here. So essentially the dissent is stating that A duty to one is a duty to all, and that comes from this idea here where everyone owes to the world at large the duty of refraining from those acts that may unreasonably threaten the safety of others. Okay, so let's go ahead and from there move on to the next idea. All right, so this next comment that I have highlighted here is going to discuss proximate cause, remoteness, continuous sequence of events, directness, and all these things just within this first paragraph here. So here it discusses that proximate cause involved, as it may be with many other causes, must be at the least something without which the event would not have happened, that being a but-for cause. So we already know the but-for cause to exist, but now we're going to move on and go a little bit deeper into our analysis, that being the remoteness, the directness, etc. So was there a direct connection between them without too many intervening causes? Is the result too remote from the cause? And here we consider remoteness in time and in space. And of course, in Ms. Palsgraf's case, the explosion happens, and almost immediately thereafter, it has the effect of causing something to fall on her. Also, within time, it is not remote in time either. I also have here the remoteness discussion. So there was here a natural and continuous sequence of events, direct connection. The only intervening cause was that instead of blowing her to the ground, the concussion smashed the weighing machine, which in turn fell upon her. There was no remoteness in time and little in space. So identifying what may be considered an intervening cause, but really this is quite direct. So these are the tools, those factors that I think could help you take your torts exam to the next level, give you a little bit of edge on other people who might not be fully exploring them. But I do want to caution, you really need to make sure this is an issue where Palsgraf is relevant and proximate cause is an issue. If it's not, you could be wasting words, okay? So if proximate cause and causation in general is not an issue, we have a very direct tort, a very direct negligence tort, I don't think you are served well by spending more than just a sentence or two showing that, hey, it's obviously there. But when it is more attenuated, that is, again, when I think you are best served by going into these factors, mentioning that they are coming from the Palsgraf dissent, and acknowledging this is a but-for and more broad causation, but it's helpful for our analysis where this is even a question, okay? So I hope this was helpful. I hope you crush it on your torts exam. And again, this was my experience. I do feel like discussing these Palsgraf dissent factors really appealed to my torts professor. Hopefully you have the same experience, but at the end of the day, you need to know your professor, and that's a case-by-case basis. But I leave that up to you.